Well, I think perhaps it might be a good time to start. For those who have joined since I last spoke, can I welcome you and say good evening? And we're most grateful to you for listening on this lovely hot evening. I'm Hilary Heilbron, and I'm delighted to welcome you all to this last in the mini-series of seminars on arbitration hosted by Brick Court Chambers. It's my very great pleasure to be chairing three of my colleagues from Brick Court in what I hope will be a session of real practical use to practitioners in the field of international arbitration, namely a discussion on some important instances of applications before arbitrators and the court. Alongside what we all know to be the exponential growth in international arbitration in recent years, we've seen three less attractive aspects of the process develop: the increasing length and complexity of cases, the increased costs of cases, and the more frequent use of guerrilla tactics in an attempt to derail the arbitration. Tonight's topics address how to combat or ameliorate some of these issues. And just to whet your appetite, let me take the metaphor forward by saying that for our hors d'oeuvre, or first course, and a substantial and hot course or topic at that, we're going to start with Saunders QC, who is going to discuss summary disposal in arbitration, something which is recently gaining more of a foothold in arbitration, though has been long prevalent, if not always successful, in litigation. Nicholas has appeared in a large number of very substantial arbitrations, ranging from oil and gas disputes to technical disputes about the design of chemical plants and patent licensing, and his practice spans commercial, competition, and intellectual property disputes. He's argued several novel points relating to jurisdiction and conflicts of laws in arbitration, and so that qualifies him well for this evening's seminar. For our next course, Jonathan Dawid will discuss how not to challenge an arbitrator, of particular interest perhaps to those of us who sit in that role. Challenges have, of course, recently been brought to our attention by the case of Heilbron and across the pond in the ICC Panama case. But I'm sure that for those of us who have had Heilbron overkill, Jonathan has a little something different to enlighten us with. Jonathan has been in practice for over 15 years with a brief interlude as a partner in a law firm. He now frequently acts as counsel in high-value arbitrations, both in commercial disputes and investor-state arbitration, and he's equally at home in the High Court. For our final course, Tom Foxton, to whom we owe a great debt in helping to organise this arbitration series, and those of us who have organised conferences and seminars before know how much work this entails. He's going to speak about interim measures, and in particular security of costs and security for claims and third-party funding. Tom joined Brick Court on completing his pupillage in September 2020 and is developing a broad commercial practice in both court and arbitration work. Each speaker is going to speak for about 12 minutes or a minute or two longer to allow for questions at the end. I'm instructed that the way that is done is for those who want to ask questions to send questions to the question box. So I'm now going to, without any further comment, to hand over to Nicholas. I and my non-speaking colleagues will disappear from your screen, though I shall briefly reappear at the end of Nicholas's session. So I think over to you, Nicholas, and we will disappear.
Thanks very much, Hilary. So I'm going to talk about whether this is one way to put the gorilla back in the cage. What's the role of summary disposition, and how can it be used effectively in international arbitration? I'll start with a few points by way of background. It was only 10 or so years ago that there was a lot of debate about the use of summary disposition procedures in international arbitration. On the one hand, there was a lot of argument about whether an arbitrator has power to address summary disposition, and that was reflected in some published ICC interim awards around that time. The alternative argument, the converse argument, was that summary disposition is inappropriate when the parties had not expressly agreed to it being a mechanism that they incorporated into their dispute resolution, and it's also inconsistent with the party's right to a fair hearing. So for many years, it wasn't entirely clear whether there was, in fact, an implicit power under various of the rules to obtain a summary disposition. And the first time you knew whether such a power existed was when an arbitrator ruled on whether there was that power within their scope. Gary Bourne, back in about 10 years ago, notably said it was something about as predictable as a pull on the handle of a casino slot machine in Las Vegas. Now, there are various reasons for that inconsistency. Obviously, the fact that there were no historically expressed rules that permitted summary disposition. Some tribunals were particularly concerned with the subsequent enforceability of their awards for obvious reasons, and that gave them pause against using summary disposition. And others had various cultural prejudices or other prejudices against summary disposition, particularly if the arbitrators come from a jurisdiction where summary procedures are not such a common feature of national litigation. But around 2010, around that time, there was a growing recognition that there could be an expanded role for summary disposition more generally. And why, the question was, but why shouldn't tribunals be able to adopt mechanisms to resolve unmeritorious disputes quickly and effectively without letting them drag on and on and on and incur enormous costs for the innocent party? There was also a push from some sectors, particularly the financial services sectors, who were very keen to have more efficient and quicker ways to determine disputes. So the question was, how far should the rules go? Should they be in relation to just purely jurisdictional issues, or more general threshold issues, something more akin to the sort of jurisdiction that we have in the English court for summary determination of aspects of the merits of the case? And of course, one point to make at the outset is that different arbitrators approach those questions and the scope of their powers in quite different ways. Former English judges, for example, on the whole, not lacking in self-confidence, are much more open to dealing with substantive questions as part of a summary determination than perhaps some of their continental colleagues. And if you think you might be making or resisting an application, choose the person that you appoint quite carefully. Paul, could we have the next slide? Thank you. So the next logical question is whether a tribunal can actually entertain a summary disposition application. That was a matter of some debate, as I mentioned a moment ago. For example, we have the old LCIA rules, the 2014 rules, which include a general power in Rule 14.5 that the tribunal has the widest discretion to discharge these general duties subject to such mandatory laws or rules of law as the arbitral tribunal may decide to be applicable. And at all times, the parties shall do everything necessary in good faith for the fair, efficient, and expeditious conduct of the arbitration, including the arbitral tribunal's discharge of its general duties. And there are, of course, also the powers that you'll see there on the slide for London-seated arbitrations that come from the Arbitration Act and that give supervisory in a supervisory context. And against that were the arguments about party autonomy and so on. In some recent cases, which I've seen, the tribunals seem increasingly open to recognising that there is an inherent jurisdiction to determine summary disposition applications, even if they're working on a set of rules which don't have an express power to do so. That, to a certain extent, depends on how confident and self-assured the tribunal is. But perhaps it is not quite like Gary Bourne's slot machine. It's now a rather more that the odds have been rather shifted. And part of the reason for that is that there has become a growing acceptance in the community, in the arbitration community, for summary determination to be an important part of the procedure. Could we have the next slide, please? Now, the new LCIA rules. So the rules were revised in 2020, and the new rules, Article 22.1, gives a tribunal the power to decide the stage of the arbitration at which any issue or issues shall be determined. So, for example, a tribunal can call out a preliminary issue. That's not a particularly contentious thing because it was something that tribunals were very commonly doing previously. But it also provides an express power to determine that any claim is manifestly without merit and thereby dismiss it if appropriate. And we see a similar thing in many of the other recent revisions of the rules. The SIAC rules, Rule 29, it enables you to file for early dismissal of a claim or defence if it's manifestly without legal merit. Article 39 of the SCC rules has a more general power, anything that is suitable to determination by way of summary procedure. There's nothing in the rules that says that has to be manifestly unsustainable or anything. It seems to be a much more general, potentially a much more general power that's incorporated into the SCC rules. So next question is, what's the test? Can we have the next slide, please? Now, there was a bit of a vogue in arbitration for arguing that the test should, particularly in London, obviously in London-seated arbitrations, be similar to that which applies in summary judgment. That hasn't met with much success because, for obvious reasons, it's a rather different sort of thing that is being determined in a summary disposition. There is obviously an inherent jurisdiction of the English court to determine summary judgment, and the question of whether a claimant has no real prospect of succeeding on the claim or issue, or no real prospect, the defendant has no real prospect of successfully defending the claim or issue, is potentially a rather different test to the sort of manifestly inadmissible one to the one that we were looking at a moment ago. Now, the principles for summary judgment are well established, but even as a matter of practicality, you do see those sorts of considerations creeping in to some of the determinations of whether summary disposition is appropriate, particularly in arbitrations where there's a UK English qualified arbitrator. So it isn't, whilst not the formal test, it is those sorts of principles, the kinds of things that are well-trodden ground in relation to summary judgment are things that do seem to catch a tribunal's eye from time to time. Can we have the next slide? Thank you. Now, 2006 was the first time we saw an express power, and that was under ICSID. Rule 41.5, unless the parties have agreed to another expedited procedure for making preliminary objections, a party may, no later than 30 days after the constitution of the tribunal, so you have to get these applications in quick, really very quickly, file an objection that a claim is manifestly without legal merit. And that kind of manifestly language is the same sorts of language that we see in SIAC and some of these other rules that have adopted a similar test. So ICSID was, to a certain extent, the trailblazer with this in 2006, and some of the later institutions have caught up with the ICSID rules. So what does manifestly without legal merit mean, at least as far as ICSID tribunals are concerned? Can we have the next slide? Now, there's quite a body of case law that's been built up in relation to ICSID, which is quite conveniently accessible on the ICSID website. One of the leading cases is Transglobal and Jordan, and in that the tribunal found that manifestly means palpable, clearly revealed to the eye, mind or judgment, open to view or comprehension, or obvious. And it requires the respondent to have established its objection clearly and obviously with relative ease and dispatch. The standard is thus set high. So, if anything, this is a higher test than the equivalent summary judgment test. It is not something which is appropriate where there is serious debate about any of the underlying principles. The tribunal further noted that that summary disposition is not something which is amenable to a wide-ranging fact-finding mission, and they were obviously concerned that if if the parties don't have the opportunity to present their case properly, there's a potential for injustice. And you'll see there just on the second half of the slide the sorts of concerns that they had in mind. It would be a grave injustice for a claimant to be wrongly driven from the judgment seat by a final award with no opportunity to present and develop its case in due course. So there is both quite a broad jurisdiction, but there's a fairly high threshold established in the ICSID case law, and it's one where the tribunal needs to have a mind to the sorts of issues that may arise from having given summary determination, particularly if they're foreclosing the ability of a party to present its case properly, which of course will have an effect on the enforceability of any interim award or an award that's made following that kind of application. Can we have a look at, can we go to the next slide? Now, the ICC rules also, even though they didn't back in 2017 have an express power, they then produced the practice note in 2017 saying that under Article 22, the tribunal shall make every effort to conduct the arbitration in an expeditious and cost-effective manner, having regard to the complexity and to the value of the dispute. So that is, again, provides that, that under Article 22, the practice note makes it clear that under Article 22, the summary disposition is part of the toolkit that's available under an ICC arbitration to enable the expeditious determination of manifestly unmeritorious claims or defences. So I suppose bringing all this together, what are the kind of practical steps? Firstly, if you're in a claim where there is as it were, a kind of threshold issue, either of one of jurisdiction or one of one on the merits. So, for example, it relates to construction of a contract or something else that is potentially amenable to a summary determination. Then think carefully about who you appoint. Some arbitrators are much more relaxed about this approach than others. And ideally, you'd want to appoint someone from a jurisdiction where this sort of procedure is quite familiar to them. Be careful about exactly what the scope of your application is. Sometimes there is a potential for things to go wrong, and what you don't want to do is bring a very wide-ranging summary determination where it's going to get knocked out in its entirety, but on the sort of point where actually your client might have been better served by holding those points forward until you've had an opportunity to properly cross-examine witnesses and so on. So summary determination works for some things, particularly jurisdictional issues or perhaps issues of construction of contracts. It's much more difficult where obviously you've got a potential for a dispute of fact, and it's very difficult, it's a very risky thing to do to bring that kind of application in a case where you have got a potential for cross-examination to reveal more at the actual hearing, because obviously by bringing the application you won't have the opportunity for that kind of evidence to be heard by the tribunal. So you have to be on issues where it is very likely that the evidence is going to come out in your client's favour at the time you bring the application. An alternative to actually bringing summary disposition is, of course, to try and split the claim up in some way, have a subsequent damages phase, or invite the tribunal to adopt a preliminary issue or something like that. Of course, those are all different things. Those sorts of applications are obviously perfectly possible. They are things, though, that are quite difficult to run with summary determination in the alternative. You have to make a decision to run an application for summary determination, whereas you might float the idea at a directions hearing as to whether it's appropriate to split the case up in some way. And it can look a bit, it doesn't necessarily look so attractive if you're pushing for two different things at that stage, where you may say that you don't particularly want to have a summary determination because it would be better served as a preliminary issue with some evidence or something. So it is quite important to get all your ducks in a row on those sorts of applications up front. The final point I'd say is if you're on the receiving end of a summary disposition application, and they are I think they are increasingly being used in a slightly meddlesome way in some cases to push the evil day when the issues will actually be determined down the track. If you're in that situation and it looks like the summary determination is going to be very involved and very drawn out and add a lot of time, it is always useful to think about the possibility of asking the tribunal to consider ordering parallel briefing whilst the summary judgment application, whilst the summary determination is still being considered, because that way, at least what it won't do is slow down the remainder of the claim if it's going to take some time for the tribunal to have considered it. So there are a few thoughts by way of practical tips. It certainly seems to be an increasingly common jurisdiction that tribunals are exercising. And as I say, some tribunals are more confident in exercising that sort of jurisdiction than others. But that to a certain extent comes from the background and the personalities of the arbitrators you appoint. Thanks very much. I'll hand you back to Hilary.
Well, thank you very much, Nicholas. I'm sure that will provoke some questions. I hope it will. For those who have joined during the course of that talk, I'm told that you should put your questions in a box called questions, which is not available to us, but I gather we will see them in due course. So I'm now going to hand over to Jonathan, who's going to tell us how not to challenge an arbitrator. Jonathan.
Thank you, Hilary. So I'm going to talk about some of the practical pros and cons of challenging an arbitrator in the course of arbitral proceedings by reference to my recent experience of a challenge in an ICC arbitration, although what I have to say will also be relevant to arbitrations under other commonly used rules, and I'll make reference in the handout to UNCITRAL and LCIA provisions. For what it's worth, you might like to know the position under ICSID is somewhat different, so I wouldn't take what I say and apply that to an ICSID arbitration necessarily. Now, most challenges to arbitrators happen on or soon after their appointment, because that's the point at which parties start digging into the background of the tribunal to see if there's any conflict or hint of bias or anything like that. But challenges can, of course, be made later, and in the case I was in was made much later, was made in the course of the final hearing on the basis of an arbitrator's allegedly biased conduct in the run-up to and during the hearing. And just by way of background, by the time of the hearing, the proceedings had been running for about 2 years. The hearing had been scheduled to have 7 days of evidence, followed by a brief gap to prepare written and oral closings, and then coming back for a final day in front of the tribunal. And the other side of the arbitration submitted a challenge to the chair of the tribunal the day after evidence finished, which was also the day before closings were due. So that came out of the blue, something of a shock to the rest of us, I think it's fair to say. To give away the punchline, the hearing proceeded the next day in front of the full tribunal, including the challenged arbitrator, and the ICC went on to reject the challenge in a plenary session the following month. That rejection was perhaps not surprising, considering that the grounds of challenge, including alleging that the chairman of the tribunal was sexist on the basis that he referred to a conference call as involving a three-way hookup, and various other allegations of, I would suggest, similar merit. But looking at the way the challenge was brought, it was notable, and I'll get to this in more detail, that the challenging party, although it made complaints about how the chairman had handled the evidence at the hearing, did not ask for a rehearing of the evidence. And after the ICC court dismissed the challenge, there was no further application to the High Court in respect of the supposed bias of the chairman. And both of those rather suggest that this particular challenge was indeed a guerrilla tactic intended either to disrupt my side's preparation for closing, or perhaps to try and get an adjournment and put off the evil day. rather than being a challenge which the other side had much grounds for belief in. And if it was a guerrilla tactic, well, it didn't work, and it probably backfired because it didn't delay closings. If it disrupted anyone, it disrupted the challenging party, who instead of preparing for closings, spent its time drafting a lengthy challenge document. But stepping back from the details of this case, what practical lessons can we take from my experience? So, can we just go to the next slide, please, Paul? So I'd say there may be some cases where it's appropriate to challenge an arbitrator during or just after a hearing, but I would suggest you need to think very carefully before doing so. Firstly, challenging an arbitrator during a hearing sends out a pretty clear message that you think you're on the losing side. Winning teams tend not to blame the referee. And even if you think that the arbitrator you're challenging has already made up their mind against you, that message is still going to be heard by the rest of the tribunal. Second, dealing with a challenge is a pain. Don't forget that. It's a pain for the tribunal as well as the parties, especially when that challenge comes in the middle of a hearing, because the tribunal has to decide, is it going to proceed with the rest of the hearing? If it decides to proceed, well, what's it going to do about the award? It's probably set aside time to deliberate over the award, but is there any point in doing that when one of the tribunal members might be removed? Under some rules, including ICC rules, all the tribunal members are asked to comment on the challenge, which is a further distraction. So making a challenge during the hearing is not going to endear you necessarily to the tribunal. And thirdly, putting a decent challenge together involves a lot of work. So if you're going to make a challenge during the hearing, that's going to mean pulling resources off other aspects of the case. So as I say, something I would suggest you always think very carefully about before you hit the button. But if notwithstanding that warning, you think that a tribunal's conduct leaves you no choice but to take some action to protect your client's position, what are your options? Well, as we see on the slide, Section 24 of the Arbitration Act makes provision for applications to court to remove an arbitrator on various grounds, including bias. But under Section 24(2), you first have to exhaust any ground of challenge under institutional rules. And since all the main rules do provide for challenges to arbitrators within the context of the arbitration, that means in practice, you can't apply to the court to remove an arbitrator without having first made an application within the arbitration. It's important to remember, though, that that doesn't mean that your only option in dealing with a wayward arbitrator at a hearing is to challenge the arbitrator in the hearing. And that's because bias, of course, is ground for challenging an award under Section 68 of the Arbitration Act. Failure to act fairly and impartially is a breach of the tribunal's duty under Section 33 of the Act and is recognized as a serious irregularity. There's a recent Chancery Division decision called Dadun and Beaton, reference 2019 EWHC 3441, which approved a passage from Russell on arbitration that failure to observe principles of natural justice, actual or apparent bias on the part of the tribunal would, if established, amount to a breach of a general duty and a serious irregularity under Section 68, and also notes the overlap between challenges under Section 68 and applications to remove an arbitration under Section 24. And the judge in that case, the Dadun case, also held that a finding of apparent bias will almost inevitably lead to there being a substantial injustice. So if you've got as far as your hearing and you have concerns over the partiality of a tribunal, you don't have to challenge the arbitrator at the hearing. You can wait until you get the award, and should it go against you, challenge the award under Section 68. And I would suggest in many cases that's probably a preferable approach, especially if there's a possibility that your challenge isn't going to be determined until after the award comes. Because it's worth recalling that under the Arbitration Act, if you make a challenge under Section 24, the tribunal can continue and make an award while the challenge is pending. So, and most rules, arbitral rules, also allow the tribunal to continue working while the challenge is pending. So if you make a challenge late in the day and the award comes out, well, in a sense, you've lost your chance to pursue that under Section 24. You're going to have to challenge the award under Section 68 anyway. So why not see if the award is in your favour, and if it's not, use Section 68 instead. Next slide, please. So there may, of course, still be occasions where a challenge to an arbitrator is preferable to challenging the award under Section 68. In particular, don't forget, a successful challenge to an award under Section 68 means essentially the arbitral proceedings, if they're going to continue, will have to start over. Whereas if an arbitrator is replaced, the tribunal could pick up where it left off. So especially if you're in the position of a claimant, you may well prefer to challenge rather than risk having to start over from the beginning. And also, you might think a challenge is perhaps preferable to going under Section 68 if the rest of the tribunal seems sympathetic, and especially if you think the rest of the tribunal may support your challenge. So if you're in one of these rare situations where a challenge late in the arbitral process looks like a good idea, when should you do it? Now, the arbitral rules generally set quite tight time limits to making a challenge. The LCIA requires it to be brought within 14 days. UNCITRAL gives you 15 days to raise the challenge, although another 30 days to pursue it if the tribunal and the other party don't agree to the challenge. And the ICC are comparatively generous, 30 days. In all cases, time essentially starts to run from the point at which you become aware of the facts and circumstances giving rise to the challenge. And that doesn't mean, it's important to recognize, that doesn't mean that when you bring a challenge, you're limited only to things happening in the last 14, 15, or 30 days. If there's a continuous course of conduct, generally you will be able to refer to things which happened earlier. And in the particular case I was in, the ICC court accepted the admissibility of conduct stretching back almost 2 years on the basis that a challenge based on a continuum of events is admissible where invoked in support of a timely invoked event. So you can have a situation in which the arbitrator does something which you think in the hearing shows him to be biased or her to be biased. You can still go back and look at other events in the past to build your case. That said, it doesn't do much, I'd suggest, with the credibility of a challenge if it looks like you've been storing up grievances for a rainy day. On the other hand, if the trigger event for a challenge comes during the hearing, then unless you've got a very long, unusually long hearing planned, you'll generally have a choice whether to bring that challenge actually during the hearing or to wait until after the hearing is concluded. In my case, the challenge was brought during the hearing, and I would suggest that's one example of how not to do things, because it doesn't give you any benefits. Under most rules, as I've said, challenging the arbitrator doesn't automatically suspend the hearing. So unless you think you're going to get a suspension, there's no benefit to challenging in the hearing instead of taking your time to gather your thoughts and doing it afterwards. And I'd suggest an immediate challenge is more likely to come across as a tactical guerrilla approach, an attempt to throw a spanner in the works rather than air a genuine grievance. So if you're in a situation where you think a tribunal member is not being impartial in the hearing, what should you do? Well, I'd suggest the first thing you should do is raise it up front, articulate your complaint to the tribunal and what you want to do about it, but don't at that point necessarily make the challenge. If the tribunal dismisses your concerns in the hearing, well, then you might want to think about a challenge. But unless time's about to run out to bring your challenge, or you think that things are so bad that you've no choice but to suspend the hearing, I'd wait until the hearing was concluded, and even then, think carefully, as I've said, whether you want to bring a challenge to the tribunal or wait for the award and challenge for irregularity. Next slide, please. So just looking briefly at the grounds for challenge under most arbitration rules, LCIA and UNCITRAL each provide for challenge based on justifiable doubts as to an arbitrator's impartiality and independence. The ICC rules are slightly different. They permit a challenge for alleged lack of impartiality or independence or otherwise, but don't describe the standards needed to show the lack of impartiality or independence. In the case I was in, the ICC court ruled that the relevant standard was conduct had to be so manifestly improper as to raise concerns as to bias. So it looks like the ICC standard is one of manifest impropriety rather than justifiable doubts, as in UNCITRAL and LCIA. Does that make any difference in practice? Probably not, I'd suggest. By way of example, Article 57 of ICSID also applies a standard of manifest lack of qualities, which is close to the ICC approach, but ICSID tribunals tend to treat that as equivalent to a reasonable doubt as to impartiality. And there's an obvious similarity between all three tests and the classic English formulation in Porter and McGill as to whether a fair-minded and informed observer, having considered the facts, would conclude that there was a real possibility that the tribunal was biased. That said, bear in mind that arbitral institutions applying their own rules are, of course, not bound by English precedent, and especially where the decision-making body, for example, the ICC court, is dominated by non-English and non-common law lawyers, they may well take a different approach to what a justifiable doubt as to bias involves. Okay, last slide, please, Paul. Another thing to bear in mind if you're making a challenge is what you want the consequences to be. Now, an inevitable consequence of a successful challenge is that the arbitrator is removed. And in most cases, institutional rules will provide for that arbitrator to be replaced. It's worth noting that the ICC rules have an exception. They permit the tribunal to continue in a truncated form where the arbitrator is removed after the close of proceedings, in other words, after the last evidence and submission, but before the award. And you can see why that might make more sense than appointing a new member to come in and make a decision based on a hearing which he didn't attend. That assumes, of course, that a challenge doesn't result in the hearing or even steps before the hearing having to be rerun. And on that point, institutional rules generally provide for the tribunal to decide whether and to what extent prior steps in proceedings should stand. There's a tension between minimizing disruption to proceedings, but also curing the effect of bias. Now, in my case, the challenging party complained that it was prevented from developing its lines of questioning at the hearing. But in its challenge also said that it was not seeking a rerun of the evidential hearing. It wanted a new arbitrator to make a decision based on the evidence which it said had been given in a tainted manner. Now, that looks to me like an obvious contradiction. It not only undermines the basis of the challenge, but it's self-defeating because it means, in effect, that you've accepted the fairness of the evidence. So suppose your challenge succeeds and the tribunal still finds against you. Well, you've lost your chance to complain that the hearing was so unfair that the award should be set aside because you've accepted that the new tribunal, newly constituted tribunal, should proceed on the basis of the original evidence. If instead you had asked for the hearing to be rerun in this circumstances, well, even if that had been refused, you'd at least have preserved your right to complain that the final award had been tainted by the biased arbitrator. So just to recap very briefly, how not to challenge an arbitrator based on conduct in the course of a hearing. Well, I'd suggest the first thing not to do is to challenge an arbitrator in the middle of a final hearing when you can wait until that hearing is over. The second thing not to do in most cases is to seek the removal of the arbitrator at or just after the final hearing, rather than waiting for the award and applying to have it set aside if necessary. And the third thing not to do is, when making your challenge and complaining of bias or other improper conduct, saying that you don't actually want the implicated steps to be rerun. Those aren't hard and fast rules. There's always going to be circumstances where you need to break one or more of them. But I would suggest that in most situations, they are pretty good. All right. Thank you, Hilary. That's all I had to say on that topic.
Thank you very much, Jonathan. Whilst we've got you there, there is a request if you could just read out again the case, the Chancery case, and its reference. Or perhaps you can do it in a different way. But
yeah, it is. Sorry, someone ringing my doorbell. It's called Dadoun, D-A-D-O-U-N, and Biton, B-I-T-O-N, 2019 EWHC 3441 Chancery.
Thank you very much, Jonathan, and thank you for that interesting talk. I'm now going to hand over to Tom, who's going to deal with issues like security, and obviously very important, because if you win an arbitration and you can't enforce it against any assets, you're in a bit of trouble. So I now hand over to Tom to give our final talk. Thank you very much.
Thank you, Hilary. Could I have the first slide, please, Paul? I'm going to talk about the interim measures that may be awarded at the outset of an arbitration. In particular, I'm going to discuss the measures that are available from the tribunal itself, as distinct from the orders that may be obtained from the court supervising the arbitration. Interim measures ordered by the tribunal tend to have fewer teeth than their court-ordered counterparts. And this is for the obvious reason that, in contrast to a court, a tribunal has no inherent jurisdiction to make orders against non-parties, nor are its orders backed by the threat of proceedings for contempt. Nonetheless, tribunal-ordered interim measures are an important part of the toolbox, not least because institutional rules will often require a party seeking an interim measure to apply to the tribunal first, before they can make an application to court. And I have a couple of examples there on the slide. I don't propose to go through them in detail. Could I have the next slide, please, Paul? So I'm going to focus on two interim measures in particular, the first of which is security for costs. Just as in litigation, a respondent to an arbitration may apply for an order protecting it against the risk of the claimant being unable to pay an adverse costs order. Where England is chosen as the legal place of the arbitration, then, unless the parties have agreed otherwise, the tribunal will enjoy a specific power to award security for costs under Section 38(3) of the Arbitration Act. And as you can see, that section is set up on the slide. Could I have the next slide, please, Paul? In addition to the default power under the Act, most of the leading sets of institutional rules also recognise the power to award security for costs, either in the form of a specific power to award security or as part of a general power to grant interim measures. So having got the framework out of the way, I'll now turn to the principles that the tribunal should apply when determining an application for security for costs. Could I have the next slide, please? As is so often the case in arbitration, there is no uniform test. What is clear, however, is that the starting point is one of general reluctance. In its 2018 report, the ICA Queen Mary Task Force on third-party funding in arbitration found that tribunals are generally far more sceptical about awarding security for costs than courts are. And three reasons are generally given for this reluctance in the literature. The first is that, in contrast to litigation, a respondent in an arbitration has contractually agreed to arbitrate with the claimant. If the respondent knew about the claimant's questionable solvency at the time the arbitration agreement was concluded, and were later allowed to raise that point in an application for security for costs, that would arguably undermine the very bargain that the parties had struck. Secondly, in an arbitration, the claimant will generally be burdened by obligations to pay in advance on costs and arbitrators' fees under the relevant institutional rules. So there is a line of thinking that those obligations are sufficient to deter unmeritorious and vexatious claims, thereby reducing the need for an order for security for costs. Third, in some cases, the claimant's lack of funds may be due to the actions or non-performance of the respondent, and so to require security for costs in those circumstances would enable the respondent to leverage its own wrongdoing to prevent the claimant from pursuing its rights. Now, that is clearly something which applies in litigation as well as arbitration, but it's nevertheless still a relevant factor. And these factors taken together have led Merkin and Flannery in their influential commentary on the 1996 Act to conclude that an award of security for costs should be made only, and I quote, in the most exceptional of circumstances, not just because there is a likelihood or even a strong likelihood that the claimant will not be able to meet any costs order. Could we have the next slide, please? So as for the particular factors that the tribunal should consider when deciding whether a case is exceptional, the best guidance appears to be the Chartered Institute of Arbitrators Practice Guideline on applications for security for costs, which was published in 2016. The CARB guideline takes the form of 6 articles, which are summarized here in Article 1. Without reading the entire article verbatim, the key points are the prospects of success, the claimant's ability to satisfy an adverse costs award, and whether it is fair in all the circumstances to require the claimant to provide security. Now, of course, these principles reflect common sense and are very similar to the factors that a court would take into account when deciding an application for security under CPR Part 25. So in the time available, I want to focus in particular on 2 factors which are of special relevance in the arbitration context. Could we have the next slide, please? The first of these is whether there has been a material change in the claimant's financial circumstances since the arbitration agreement was concluded. As I have already mentioned, one reason why tribunals are generally reluctant to award security for costs is because of the contractual nature of arbitration. The parties have agreed to arbitrate, and if the respondent knowingly entered into a contractual relationship with an impecunious counterparty, it should not be permitted to pray-and-aid that impecuniosity in order to impede the performance of the arbitration agreement. Accordingly, it is not generally enough for a party merely to show that the claimant is impecunious. The applying party will also need to show that said impecuniosity was not reasonably known about at the inception of the party's commercial relationship. And that test is reflected here in paragraphs B and C of the commentary on Article 3 of the CARB guidelines, and it is sometimes referred to as the material change in circumstances test. Could we have the next slide, please? Another important question is the extent to which the presence of third-party funding is relevant to the award of security for costs. The first issue that this gives rise to is whether the mere existence of a third-party funding arrangement should be regarded as a material change in circumstances. The ICA Queen Mary Task Force rejected this suggestion, and I think quite rightly, essentially for 2 reasons. First, it noted concern that non-funded parties would use an assumption of impecuniosity to justify routinely making security applications, and that then might have the effect of deterring meritorious claims. Secondly, and I think more importantly, the task force noted that since funding is widely used even by financially stable parties, it would not be a reliable indicator of a material deterioration in the claimant's finances. A second respect in which the presence of third-party funding may be relevant is as a factor going to the question of whether it is fair to order security for costs. Now, in particular, it has been suggested that funding agreements can create an asymmetry between the claimant and the respondent by enabling the claimant to arbitrate as if it were solvent, while at the same time not assuming the economic risk of the arbitration. However, whether or not that is the case will largely depend on the termination rights under a given funding agreement, and more importantly, on any codes of ethics that restrain how funding agreements can be structured in a given market. Ultimately, the ICA Queen Mary Task Force has suggested that the presence of a funding arrangement should not normally be viewed as a factor in favour of awarding security for costs. Indeed, the task force has concluded that a funding arrangement may sometimes point against awarding security for costs in cases where it would otherwise be ordered. And the key examples that are given are, first, when the funder's termination rights are structured in a way so as to minimise the risk of them walking away during the arbitration, and second, where the party has after the event insurance. Could we have the next slide, please, Paul? Now, these principles apply differently in investment arbitration, and it's fair to say I think there's a lot more controversy in investment arbitration about when and whether security for costs should be ordered. I don't have time to go into those issues in any detail, but I will flag 2 points for consideration. First, there are actually conflicting decisions about whether there is even a right to security for costs in ICSID arbitration, with different tribunals going different ways. Secondly, investment arbitration tribunals tend to apply a stricter standard, often requiring evidence of abusive conduct or bad faith on the part of the claimant before they will be willing to order security for costs. And that has been linked to broader policy debates about investment arbitration. Could we have the next slide, please? So turning then to the second interim measure that I want to talk about, that's security for claim. This is an interim measure that allows the party applying to secure the amount it is claiming in advance of a final award. And that, of course, ensures the availability of funds against which the final award may be enforced. Unlike security for costs, the Arbitration Act does not contain a specific power to award security for claim. And in this respect, the position in England can be contrasted with that in Singapore, where the International Arbitration Act specifically gives tribunals the power to secure the amount in dispute and also the power to prevent dissipation of assets so as to ensure that an award is not rendered ineffectual. Security for claim, while not a default power under the English Arbitration Act, is, however, available under most sets of institutional rules. And again, I've set out the relevant provisions on the slide. As with security for costs, there is no uniform test when ordering security for claim. But given the analogous nature of the relief, it has been suggested that the tribunal should apply something akin to the test for awarding a freezing injunction. That is, whether there is a real risk of dissipation of the respondent's assets between the commencement of the arbitration and the time for a final award. I would suggest that that is an apt test, and I would note the analogy between an application for a security for claim and an application for the payment of an award into court pending an appeal under the Arbitration Act. In that circumstance, the court does in fact apply a test very similar to that which is applied when considering whether to award a freezing order. And I think there's a very strong analogy between the payment into court on an appeal and the payment of the claim upon the initial determination of the arbitration. Could we have the next slide, please, Paul? So finally, a few practical points to finish on. In terms of how security should be held, it's typically posted by way of payment into escrow or the provision of a bank guarantee. But it should be noted that many arbitral institutions will, for a fee, perform the holding function in a dedicated bank account. Another issue which can arise is a situation where a party wishes to seek an interim remedy, but before the tribunal has been formed. Now, in these circumstances, the applying party may be advised to seek an interim measure from an emergency arbitrator. And indeed, there is English case law to the effect that if institutional rules do provide for such a procedure, and timely and effective relief could be obtained from the emergency arbitrator, then the English court will generally decline to grant relief under Section 44 of the 96 Act. So there's a clear message that if you have this procedure available to you, and you would be able to obtain effective relief, you can't sidestep that procedure by making an application under Section 44. And that case is Gerald, Metals and Tinnis, and the citation is 2016 EWHC 2327. If the opposing party fails to comply with an order for an interim measure, then of course it's always possible to make an application under Section 42 and then get a court order enforcing the order of the tribunal. And as a final point to finish on, by analogy, when one is looking at injunctions in the context of litigation, it's always important to consider whether one should apply for a cross-undertaking or cross-indemnity. The LCIA rules make specific provision for this and direct the arbitrator's attention to whether it would be appropriate to order a cross-indemnity. But even where institutional rules don't explicitly identify a power to order a cross-indemnity, I would suggest that such a power is nevertheless likely to be implied from the availability of security for costs to begin with. So that concludes my presentation, and I'll now hand back to Hilary to field questions.
Well, thank you very much indeed, Tom, for that interesting and very practical talk. We have some questions from the audience, and so I'm going to go through them. I might just summarize them. First of all, for Nick, on the question of manifestly without merit, there's a question which asks whether you see a difference between the test used in ICSID, which is manifestly without legal merit. And the question is, to what extent do you think the addition of or not of the term legal makes a difference in practical terms as between commercial and investment arbitration? And would you consider that ICSID presents a higher test than the LCIA and others?
Well, I'm not sure it's necessarily a higher test, but it may be one that focuses on slightly different things. It's arguable, probably, that if you include the word legal, manifestly without legal merit, then that might narrow the jurisdiction that the tribunal has. So manifestly without merit might encompass broader things, like imagine I took a ridiculous position on the evidence. I said that the contract was frustrated because I was abducted by aliens on the day that I was due to perform. Now, a tribunal might say, well, that's obviously completely bonkers, and take a view that that's so incredible that they dismiss it on the facts. But if the test is manifestly without legal merit, that would suggest that actually it's more about whether a particular cause of action is made out rather than giving the tribunal the power to dismiss things on purely factual grounds. So there may be a distinction there. I think in both cases the test is likely to be the same sort of test in terms. I mean, the manifest test is a similar threshold for both.
And for Jonathan, it's really a comment, but you might want to make a comment on the comment from Paul Rose, who was apparently on the team with you and was also deputy counsel at the ICC, making the point that 9 out of 10 challenges are generally not upheld, together with the point that sometimes you might be at a disadvantage if you've once lost a challenge before the ICC. It might be more difficult later to convince a court somewhere along the line to overturn that decision, since the ICC is globally respected and held in high esteem. Do you have any comment to add to that, Jonathan?
I think the only comment I'd have is that because pretty much all the institutional rules have a challenge process, and Section 24 of the Act requires you to make use of that process before you apply to court, you're not going to get to court on a challenge without having already lost before, whether it's the ICC or the LCIA or some like body. So I agree, having lost once, it's not going to make things any easier for you, but that's sort of the way the process works.
And this may be the same question, but perhaps it's got wider application. If an issue's been ongoing throughout the proceedings, including during the hearing, could you face criticism or sanctions, for example, on costs, or be timed out by waiting until the war? I think this is the same point, which I think you now answered, so I won't repeat that. For Tom, doesn't Section 38(4) provide the tribunal a power to order preservation of property? So isn't that a sort of security for the claim?
Yeah, so I think it ultimately depends on what the subject matter of the arbitration is. So in a commercial arbitration, often what's being sued for is money, because there's been a breach of an agreement that's left the counterparty worse off. And in that case, although one might loosely describe the money as property, there is no property in specie, which is the subject of the claim. Now, it might be different perhaps if you had a proprietary claim where what your claim was for was specific monies held in a bank account that you traced into. But I would suggest that that type of claim is unlikely to arise in the context of an arbitration. Alternatively, where one might rely on Section 38.4 is if one has an investment arbitration where one really is having a dispute over a particular piece of property, and then one might say that, well, what happens is the property needs to be sequestered, and you could rely on Section 38.4. But I think those cases are going to be very few and far between. So generally, I'd say it would be a creative argument in the run-of-the-mill case, but I'm not sure you quite get there on the analysis.
Now, I've just got one or two questions before we close the session. Nick, I'm just going to ask you this. One of the problems you often find when one side wants to do a preliminary issue is the other side will try to make it all terribly complicated, and you can't decide it without lots of evidence. How do you see that playing into this narrower application of manifestly, what's the phrase? I've just lost it now.
Manifestly without legal merit.
Manifestly without legal or manifestly without merit. Do you see that that's going to leave scope for people to try and derail that application?
Well, I think there's always scope for derailing applications. That's part of the game. But I mean, the tribunals generally have very broad jurisdiction under most rules to hear parts of the case early as a preliminary issue. The usual debate about that, and it's the same debate that happens in the commercial court, is whether the issues are sufficiently defined and that the scope of the evidence and so on is sufficient. Is sufficiently tight that the tribunal can deal with it in a sensible way, and that what they're deciding will help determine a decent chunk of the dispute. And that in a way is a slightly different, that's a rather more flexible sort of test than the kinds of things that we have under the summary determination. I think if anything, you can bring a broader scope of issue as a preliminary issue or as a staged trial. For example, one of the things that happens is that that's done in competition where there's a competition defence or something else. Various other aspects of the claim will get decided before hearing all the evidence on competition. So you might deal with construction of a particular contract up front and then have a competition defence that's considered if the arguments on construction fail. And so there are ways of staggering things, but that's much more flexible than determination.
I suppose if it's manifest, it should be clear-cut and narrow to preempt that sort of question.
Exactly. Whereas actually, some preliminary issues are very hard to decide, I suspect. So it's not.
I've got one other question. The tribunal can obviously make an award or an order, as we've heard and as I know from past experience. Orders have limited sanctions. So if you're seeking to say that something's manifestly without merit and you want to dispose of it quickly, the better option, I assume you would agree, would be to go for an award. Of course, that may take time if it's, for example, the ICC, because it would have to
Yes, because you have to go through the approval process and everything else with the ICC. I mean, I think you're much better off under the New York Convention if you're trying to enforce if you've got an award in your hand. So generally speaking, it's much better to go for an award.
Question for Tom. One of the things one often finds when one's looking at security, because so many cases involve them, are SPVs. Do you have any comment on what one should do when a party comes out and says, oh, well, it's a special vehicle, special purpose vehicle, it's got no assets? How do you consider one should approach that?
I think this is where the material change in circumstances test becomes very important. Because if the position is that you knew that you were contracting with an SPV at the time you concluded the arbitration agreement, then a reasonable person in the position of the parties would then have to say, well, you knew that we were near insolvency or didn't have very many assets, and it's now abusive for you to pray and aid our impecuniosity in order to bring a security for claim application. So I think it really depends on what you knew at the time you concluded the agreement. But if the position is that there's some new evidence that's come to light and you only know at the time of the arbitration that they're now impecunious, I think that then might make a difference to whether you can get the remedy.
And finally, Jonathan, the antidote, of course, to challenges, but it can bring challenges, is for arbitrators to disclose going along the line. And sometimes one has to disclose during the course of the hearing. But of course, the test is different for challenges and disclosure. Do you have any comments on that at all in the context of what you were saying?
In the context of what I was saying was more to do with conduct, therefore disclosure didn't really arise. But obviously, if something comes up which ought to be disclosed, and that's likely to give rise potentially to a challenge, and the arbitrator, if he doesn't disclose it, is going to open up the awards to a Section 68 challenge in due course.
Well, let me end with a story against myself. I was doing an arbitration a few years ago, and I was going to the IBA conference, and I'd been invited to a 3 Michelin star restaurant in an Italian city, I think it was Milan, by the firm who was appearing before me, although it was completely different solicitors. And I did disclose it in the hopes that they would say, oh, well, of course, it's irrelevant. But unfortunately, they stopped me having my 3-star dinner in an Italian restaurant, but I've forgiven them. But so sometimes there are consequences. So on that note, talking of dinner and the lovely sunshine, may I thank, first of all, our panelists for their excellent contributions, and also thank our attendees and those who stayed the course. And I hope you have found it enjoyable and useful. Thank you very much indeed.